At the very heart of the American legal system, there's this constant tug of war for power, right? It's the federal government versus the states. And today, we're going to talk about the constitutional doctrine that acts as the ultimate referee in this fight, federal preemption. So, to make sure this doesn't just feel like some abstract legal debate, let's start with a really direct, high-stakes question. Can a state, any state, just decide to create and enforce its own immigration laws? Well, back in 2010, the state of Arizona basically said, yes, we can. They passed a hugely controversial law, SB 1070, and in doing so, they lit a match. It created this massive legal and political firestorm that put them on a direct collision course with the U.S. government. And that collision led to a landmark Supreme Court case, Arizona versus United States, which is a perfect real-world example of how federal preemption actually works. So here's the quick and dirty. Arizona's law essentially gave its own state and local police the green light to enforce federal immigration laws. The U.S. government immediately sued, saying, whoa, hold on, immigration is a national issue, that's our job. And in 2012, the Supreme Court, for the most part, agreed. They struck down the core parts of that Arizona law, and the legal tool they used to do it? You guessed it, federal preemption. So how can that happen? How can the Supreme Court just invalidate a law passed by a state? To get that, we actually have to go all the way back to the source code of federal power, the U.S. Constitution itself. It all boils down to this one incredibly powerful line in the Constitution called the Supremacy Clause. It establishes a crystal-clear hierarchy. When a federal law and a state law are in conflict, the federal law wins, period. It is, quite literally, the supreme law of the land. And that constitutional command is what gives life to our topic today, the doctrine of federal preemption. It's basically the legal principle that says federal law can displace or preempt state law. This is how the Supremacy Clause is actually put into action. But, okay, how does it really work in practice? It's not always so simple. The courts have basically identified two main ways that federal law can push state law out of the way. Let's break those down. So, as you can see, the two big categories are express preemption and implied preemption. Express is pretty much exactly what it sounds like. But notice how implied branches off into two other types, field and conflict. We're going to see what each of those means right now. The difference here is pretty straightforward. Express preemption is when Congress just says it, right there in black and white. They write into a law, this law supersedes any and all state laws on this topic. Easy enough? Implied preemption is, well, it's a lot trickier. That's when courts have to read between the lines and figure out that Congress intended to preempt state law, even if they never came out and said it directly. All right, so let's dive into that trickier implied category. First, you've got field preemption. This happens when the federal government has regulated an entire area so completely, there's just no room left for the states to do anything. Think about alien registration, which was a huge part of that Arizona case. The feds have that field on lockdown. Then there's conflict preemption. This one is pretty logical. It's either when it's literally impossible to follow both the state and federal law, or when the state law stands as an obstacle to what Congress was trying to achieve. A perfect example is a state trying to force a drug company to change a label that the federal FDA has already approved. You can't do both. Now, after hearing all that, you might be thinking that federal law just steamrolls state law all the time. But there's a really important check on that power that's built right into the system. Which brings us to the big question. Does the federal government's argument for preemption always succeed? Does federal law always win? And the answer is a definite no. And the reason why is wrapped up in this classic quote from a 1947 Supreme Court case. The court declared that federal law does not automatically override state law unless that was the clear and manifest purpose of Congress. This idea is called the presumption against preemption, and it's a true cornerstone of this area of law. What it means is that courts start their analysis from a default position. They assume Congress does not want to interfere with the traditional powers of the states. Things like public health, safety, and general local matters. So, and this is the crucial part, the burden of proof is on the side arguing for preemption. They're the ones who have to prove that Congress's intent to override the states was clear and manifest. And this principle is so important because this balance of power between the feds and the states, it's not set in stone. Not at all. It's been shifting and evolving for centuries. And really, that's the key takeaway here. Federal preemption isn't some simple on or off switch. It's this living, breathing, and often really contentious legal tool that our country uses to constantly negotiate the boundaries of power. And you can really see this evolution play out over time. In the early part of the 20th century, the courts were pretty quick to find preemption. But then, in 1947, that huge Rice case came along and created the presumption against preemption, which really shifted the balance back toward the states. That idea was powerfully backed up again as recently as 2009. And today, the debate is hotter than ever as more and more big issues from climate change to data privacy go national, which just fuels the fire in this debate between uniform federal rules and state-level control. So that really leaves us with a final massive question. In an era like ours with such deep political and social divisions, who should be taking the lead on the biggest issues we face? Should it be the states or should it be the federal government? The never-ending debate over federal preemption is exactly where that fundamental question gets hashed out, year after year.
This is for entertainment and educational purposes only. This is not legal advice.